I'm Barry Marks with Marks & Associates, and I'd like to share with you some of what I've learned over the years representing banks, equipment lenders, and equipment leasing companies. You know, one of the things that we're often asked is, why do we have to get all this paper signed in order to do a simple equipment lease? And certainly in the small ticket area and the lower end of the middle market sector, that's understandable. Look at it this way. The officers of a corporation have the right to do whatever they need to in the ordinary course of their business. That means they don't have to get approval from the board of directors in order to sell their product or enter into a simple agreement that is part of what they are doing for a living. Is leasing equipment from your company or financing equipment in the ordinary course of their business? That's a difficult question to answer. And where possible, we like to have a board resolution that specifically states that it is approved at the higher level. The way I have sometimes described this, however, is that, well, there's a difference between a bakery that is leasing a delivery truck or an oven and the president of the company who is leasing a Mercedes-Benz that he may be giving out to somebody else. Always consider carefully whether you really can do without that certificate, and recognize that the game you're playing is letting the lessee out altogether in the event it's determined that the president or officer of the company didn't have the power to sign the lease in the first place. The situation with guarantors is a little different. Some corporations are created simply to guarantee obligations of their affiliates, but 9 times out of 10, executing a corporate guarantee, even if it is permitted under the laws of the state in which the corporation is organized or the LLC is formed, usually that isn't in the ordinary course of the guarantor's business. We're a little tougher on asking for resolutions from the board of directors in the event that we have a guarantee involved. Another thing, the certificate that probably contains those resolutions and is signed by a secretary stating that they've been adopted also has the very important incumbency information. Specimen signature of every officer who's going to be signing the lease or any other document, and a statement as to what that officer's title is. This is a very important fraud prevention, and it can avoid, at the very least, a lot of trouble and confusion down the line if someone doesn't remember having signed what he signed. Again, it's probably more important for the guarantee even than the lease. For information about these and other topics, visit www.leaselawyer.com.